Our program here is on Proposition 65 in California, and then a variety of hot topics in food litigation from around the country. So I'm going to begin by introducing my partner and good friend, Ken Schmidt, who hails from Dorsey, Southern California office. So he is in the thick of things and has been, every time I try to reach him, he's putting out fires on Prop 65 matters. And so he's got a lot to share with you. And then toward the end, we may tell a little war story about a food labeling case that we're currently handling in San Diego. But we'll wait till the end for that. Kent, why don't you take it away on Prop 65?
Sure. And for the last several weeks, and actually a couple of months, a great deal of my time has been spent on Prop 65 because of some rather significant regulatory changes that have taken place, which have caused a great deal of activity and consternation among those in supply chains, not just in the food space, but all types of consumer product manufacturers and retailers, as well as other industries. So we'll get into that in a little bit. So I'd like to talk about a couple of broad brush topics relating to Prop 65, sort of setting the groundwork for perhaps those that are less familiar with the statute. I'm sure most people recognize that Prop 65 is a labeling statute in California, but because it triggers litigation claims for any product sold in California that it violates the statute, if you have a market that touches directly or indirectly consumers in California, it's of great concern to you. It is a very unusual statute in that in your typical statute, you basically have conduct that is prohibited, and if you violate that statute's predicate, then there's a penalty for it. There's some consequences for it. You would think that if the objective of the statute is to cause product manufacturers, among others, to not expose individuals to certain chemicals, you would have the exposure prohibited. Instead, the statute seeks to accomplish that objective in sort of a roundabout way by, instead of prohibiting the inclusion of chemicals in products, simply requiring a warning so the consumer can make an informed choice. The objective behind the statute, however, is not that you would put a warning, even though that's what is required by the statute. So it makes it very unusual. Instead, the real objective of the statute is reformulation. The statute, and I say this to clients all the time as they hear what they have to do or what is prudent for them to do, and they say, this is so burdensome. And I remind clients from time to time, the statute's meant to be burdensome because it's meant to nudge you not to put a warning on your product, but to reformulate your product so it doesn't require a warning. And so it's important to keep that in mind. There are really two spheres within the statute's focus. There's cancer, chemicals that cause cancer, and there's reproductive harm. And the list of chemicals has grown since the statute was enacted in 1986. Well, it was enacted in 1986. The chemical list developed in 1987. It's gone from 30 chemicals on the list to 900. Just knowing that fact underscores how daunting compliance with the statute is. When you talk about testing for a product, it really is almost impractical, if not impossible, to test for every chemical that's on the product. So you have to go through a process of knowing what the likely suspects are and testing for those. The draconian penalties make the statute very, very scary. People always ask me, so does it mean $2,500 penalty per product that I have out there on the market? No, no, no. $2,500 penalty per exposure. And that's why the first question, when I'm trying to settle a Prop 65 case, the first question plaintiffs always ask me is what? What's well, actually, they presume liability. So the first question that they ask me when we're trying to settle a case is, what are your sales? Because they want to do some simple multiplication and say, what's the worst case scenario? Because we're going to multiply $2,500 per exposure. And so in those situations, I'm always happy when my client has had a very dismal experience selling the product, because that means the lower the penalty. So it's a very draconian penalty, and that, of course, impacts the settlement, and 99% of these cases end up in some sort of settlement. The plaintiffs, or the parties that bring these cases, fall into two categories. There are the public prosecutors, the district attorneys, and the attorney general, but they represent a very small minority of the parties bringing these. Instead, these are private plaintiffs that bring these Prop 65 claims. That's all preceded by what's called a 60-day notice and an opportunity to settle early on before they even file a lawsuit. And it has spawned a very lucrative cottage industry in California of law firms with lots of lawyers, sizable firms that do nothing but churn out Prop 65 notice letters and settle these like a mill. And I deal with this exact same plaintiffs' lawyers repeatedly. I've probably done about 30 or 40 Prop 65 litigation matters, and so I deal with the exact same players in the industry, and they make a very, very significant amount of money doing this. The other concept that's unusual in Prop 65 is the safe harbor concept. So you have this sort of a scary prohibition, significant draconian penalties, but you have the concept of safe harbor. If you, with respect to both carcinogens and with reproductive harm, if you meet certain levels with respect to particular chemicals, then it is a safe harbor. You have a presumption. But if you exceed that, you're going to have to prove that there's not an exposure that triggers a warning. And so what that means is that the burden shifts from the plaintiff to the defendant. This shifting of the burden basically rewrites the litigation playing field. In virtually every other civil litigation matter, the defendant doesn't bear the burden of proof. And that's true even in the consumer class action food labeling cases that Chip's going to talk about momentarily. Even in those cases, as plaintiff-friendly as the landscape is, the plaintiff bears the burden of proof. Not so with the Prop 65 claims. Once it's been proven the chemical exists, then it's on the burden of the defendant, the manufacturer or the retailer, to show that the exposure level is not such that requires a Prop 65 warning. And if you don't fall under one of those safe harbors, then you've got to prove it in a different way. And even if you are within one of the safe harbors, you have to get experts, you have to do a lot of analysis of the product, and it's going to be a battle of the experts, and it makes these cases very, very expensive to litigate. The settlements and the volume of the settlements and the oversight that the state has over these settlements does create a very rich database of information that you can glean from, because all of these settlements have to be reported to the Attorney General. They all have to be approved by a court if it's going to have preclusive effect and prevent a follow-on lawsuit. So if you really are serious about not having a second lawsuit, you've got to go through this process. And all of this data is online. You can do searches for products, you can do searches for chemicals, and so you can start drilling into this database and learn quite a bit about your particular sector or industry and where the hot spots are. And that's one of the preventive measures that you can engage in to avoid Prop 65 claims. So that's a bit of an overview of the statute, some of the unique features that we deal with. Now let's talk about what's going on, what's happened over the last several months, including new regulations that have taken place or that have been enacted. The regulator that oversees Prop 65 as OEHA, kind of a funny way to put it, but that's the Office of Environmental Health Hazard Assessment. And they've had some concerns about Prop 65. Industry's had some concerns about Prop 65. The regulators have had concerns about Prop 65. The regulators' number one concern about Prop 65 is, in a strange way, how much companies comply with the law. What do I mean by that? Because we have a phenomenon of overwarning. And it's like the boy who cried wolf. Everyone is putting a warning on the labels, like the Oprah Winfrey scenario. You get a warning, you get a warning, you get a warning, everybody gets a warning. And so as a defensive strategy, companies just put this sort of vague warning on a box, they put it in an owner's manual, and they say, I'm covered. And they don't do the testing, they don't do the reformulation, they still buy the product sourced from someplace in China, they have no idea where the raw materials are coming from, and the law doesn't accomplish its purpose because there's no reformulation. It doesn't even accomplish its purpose of giving the consumer something that's real, because the consumer looks at it and ignores it. And so the regulators hate the overwarning. That the Attorney General will reject settlements that, or oppose settlements that have a warning requirement that's just done in order to resolve the case when it's not really required. Overwarning has been an issue for some time. There's also concern, given the sort of lack of, the not paying attention to the warning, that people don't really understand what the exact chemical is that's in the product, because no one's testing the product, they're just putting a generic warning on it. And so the new emphasis over the last couple of years that have culminated in these recent regulations is to require greater specificity with respect to what the chemical is that is being warned of. There's also been a concern by the regulators that the small business in California is the one that's left with the liability, and the big supplier that's outside of California is the one that is sometimes difficult to reach, and sometimes it's impossible because they're even in China or some other place where it would be impossible or difficult to enforce a judgment. And the retailer is the one that is least capable of testing the product, understanding where the raw materials are that were sourced for the product. And so there's an emphasis in trying to figure out how to shift the responsibility, at least to some extent, upstream to the manufacturers. And so this apportionment of responsibility between retailers and suppliers is a very significant emphasis in the new regulations. So new regulations came into effect August 30th, 2018. They're rather complex. I spent an entire day in San Francisco on Monday at a conference that was comprised of regulators, the plaintiffs bar, the cottage industry, as well as defense lawyers. And there's a lot of confusion about the warnings. But the focus, the new regulations. The new regulations focus is on a number of things. Number one, the methods and the contents of the warnings. What is conveyed, how it's conveyed, and consistent with the safe harbor concepts that relate to the exposure concept, that piece of the analysis. The new regulations follow the same sort of safe harbor concepts. So they're not mandatory methods of communications or language of communications, but they're a series of regulations that say, if you convey a warning using this method, and if you convey a warning using this content, it's a safe harbor. It's sort of a false assurance, though, because the safe harbor sounds like it would be friendly to defendants. It sounds like, oh, this would be great. As long as I comply with the safe harbor, this would be great. And in theory, it's true, but the safe harbor makes it virtually impossible if you don't fit within that safe harbor to say the method in which I convey the warning is sufficient, otherwise, or the content is sufficient. So, and also, when you look at the regulations, the new regulations, even these safe harbor regulations, they create more questions than answers. So that's the first thing, is that there's greater specificity under these safe harbors with respect to the specificity of the chemical that's being warned of. There's also a whole section relating to apportionment of liability between manufacturers, and in a sense, I'm going to just sort of paraphrase this. What these new regulations say is a retailer can ask their manufacturer, hey, what's in this product? What do I need to do to warn? And can essentially rely on the manufacturer's representations as to what warning is required, the method in which it's going to be conveyed, and as long as they follow those reasonable instructions, there are some exceptions to that. As long as they follow those reasonable instructions, they have not immunity, but they at least have a defense. So it's working to try to shift that responsibility up the chain in the distribution. So that's a second concept of safe harbor that also applies with respect to retailers. And then there are a number of safe harbors in the new regulations that are specific to various industries and contexts and chemicals. So there are sort of general safe harbors, and then there are sort of industry safe harbors. And as you might guess, there are some safe harbors that relate to food and beverage. So that's where we're going to spend a little bit of time. I won't go through all of the details of these safe harbors, but consistent with the general framework, there are safe harbors that talk about the method of the transmission for a food product label and how that warning is to be conveyed. And then there are content requirements, including the type, the font size, the fact that it has to have warning that's listed, and that it has to have a box around it. So these are very, very specific. Now, what happens if your product, for example, doesn't have a box around it, right? Or the printer forgot to bold the word warning. Is it non-compliant? No, it's not non-compliant, or I should say, we may be able to argue that it complies. Because remember, these are merely safe harbors. And so we would then, in that position, be arguing that the method and the content is reasonable, informing the consumer, even though it doesn't fit within the safe harbor. However, as we've seen over the last several years with the safe harbors that relate to exposure levels, when you're on the plaintiff side, you're going to say, hey, if you don't follow the safe harbor, I'm going to argue that it wasn't reasonable. The safe harbors are there for a reason. So it becomes somewhat of a non-optional standard, even though technically it's not necessarily a non-compliant product by falling outside the safe harbor. There are new regulations that also relate to alcoholic beverages. There are new regulations concerning the content and the warning conveyance requirements for restaurants, including the size of the placard that should be at the restaurant, the specificity. So you see these regulations are very, very specific. And it's a whole new world, because before we just had this sort of general requirement of the warning being conveyed in a reasonable manner. Now we have all these specific requirements, although I keep saying requirements, but specific safe harbors. But the safe harbor is essentially tantamount to a requirement in a litigation standpoint. Here's a very interesting question that I think is apropos to the food and beverage industry. So OHIA, I think, does a pretty good job trying to educate industry, and they do it through a number of websites. Their website's actually very helpful, and they do FAQs, and they came out with a series of FAQs in conjunction with these new warnings. And this is one I thought was worth reproducing in full in your materials. It has to do with the concept of ingredients. So you're a manufacturer of an ingredient, that has a Prop 65 chemical in it, and you're selling the ingredients to a variety of manufacturers who are going to include your ingredient in their product, okay, your chocolate in their chocolate chip cookies. And what I interpret this directive or this clarification to be is that you have to do some sort of assessment as to how your ingredient is going to be used in the finished product. And if that finished product with your ingredient in it then exposes the consumer to a chemical that would require a warning. I think that puts a very, very significant burden on you as the ingredient manufacturer, because now instead of just selling your chocolate chips to 100 different manufacturers, you've got to have a better understanding as to what the typical, reasonable, or anticipated number of chocolate chips, to go with our metaphor or our analogy example, a number of chocolate chips that are going to go into the ingredient, and then the final product is going to be tested to say, with 7 chocolate chips in a serving size, is this going to require a warning? And then the question is, of course, to extend this, how many chocolate chip cookies is someone going to eat on a given day? And are they going to eat chocolate chip cookies every single day of their life for the next 10 years? You get into these types of analysis as to whether a warning is required, and you deal with some imponderables. You deal with some very vague questions. And when you have a very motivated cottage industry plaintiff's lawyer that's coming up with scenarios and is coming up with assumptions, you can see where reasonable minds, putting it charitably, we'll say reasonable minds can differ as to whether a warning is required. So I think the ingredient component or component parts for other non-food manufacturers presents some scary questions for the ingredient manufacturer. I want to now just deal with, in the balance of our time, the 5 sort of hot chemicals or carcinogens that are most active in the food space. And of course, if you've been following, and I know you all have, just general news in the industry, you know that acrylamide has been the hot ingredient or the hot chemical in Prop 65. It's been on the front pages of the Wall Street Journal and New York Times. It's been such significant attention. With respect to acrylamide, coffee is, of course, was the big issue, because Starbucks and the other coffee retailers had to put up the signs. And I remember the first time I walked in my Starbucks and saw a Prop 65 sign, I just couldn't believe it. Then, of course, we became very used to it, and everyone ignores it. And then, as I said earlier, 99% of these cases settle. Well, the coffee manufacturers and retailers decided to take one of these cases to trial. So they went to trial before Judge Burrell in Los Angeles Superior Court earlier this year, and things didn't go well. And Judge Burrell said, no, I think that coffee requires a warning. And so all of a sudden we're looking at massive, massive penalties. Remember, $2,500 per exposure. That means every single cup of coffee sold by the defendant retailers in the state of California for 1 year prior to the filing of the action is a $2,500 penalty.
That's big money from you alone, right?
Yeah, that's serious money. Next thing we know, we're talking about some serious, serious money. And so, thankfully, even common sense sometimes prevails with California regulators. OHIA basically came out with a new guidance on regulation that basically had the effect of overriding Judge Burrell, and said, no, we really don't need warning labels on coffee. Acrylamide is still a concern, but with respect to coffee, we don't believe that the exposure level from drinking a cup of coffee is such that it requires a warning. However, that doesn't mean that acrylamide is not a significant issue of concern, because in other contexts, including French fries and potato chips, there have been multi-million-dollar settlements on Prop 65 with acrylamide. What's the issue? Why is it different? Well, one of the differences is the ability of the manufacturer to remove or reduce acrylamide from the product. And one of the defenses that the coffee manufacturers advance is you cannot have dark roasted coffee without acrylamide. Maybe 10 or 15 years from now, we'll figure out how to do that, but we haven't figured out how to do that yet, number one. Number two, the health benefits of drinking coffee outweigh the minutia of acrylamide exposure, and therefore, all things being considered, this is not a product that people should avoid. So acrylamide's a big issue, and it's going to continue to be probably number one in food space. Glyphosate, major issue, major concern. There's been a lot of litigation as California added it in 2017 to our infamous list. And immediately, 2 lawsuits were filed in state and federal court, somewhat parallel. The state court action was not successful. The federal court action was successful. And there is a preliminary injunction issued in the Eastern District of California prohibiting the enforcement of the Prop 65 for glyphosate. Interestingly enough, it was a very unusual defense that prevailed and saved the day for the wheat growers in the Eastern District. It was, of all things, a First Amendment defense. And it's related to this whole concept of forced speech, which the U.S. Supreme Court, as you may know, last year issued a very significant ruling on forced speech in the context of another California regulation that required pregnancy planning centers to advise on the availability of abortions from the state. And the U.S. Supreme Court said, no, this is a controversial issue, and for the state to require, on a matter of great controversy, these counseling centers to give this speech violates their First Amendment rights. And so, and of course, this came down before that decision, but it's the same concept that there's a great deal of controversy relating to glyphosate. It's not settled. There's a great deal of dispute as to whether it is causes any harm. Given the current state of the science on this, it is a matter of great controversy. And of all things, this came as quite a surprise to me. The Prop 65 enforcement of this particular part of the regulation violated the First Amendment rights of industry. Whether that stands and they get a permanent injunction, who knows? But that case, the National Association of Wheat Growers, is garnering a lot of attention. BPA is, of course, another issue with respect to cans. There is a safe harbor exposure level that relates to that. It's one of the new regulations, and so that's, of course, of great interest to industry right now. And I have the materials in there regarding that. So there's both a exposure level safe harbor, and there's a safe harbor with respect to the manner of the warnings. The next on our hit parade is DEHP. DEHP has, as a result of Prop 65 and other legal action, industry has done a great deal over the last several years to essentially eliminate DEHP from food packaging. But the chatter that I'm hearing in industry right now, or among the plaintiffs bar, and by the way, this event I went to in San Francisco is so fun because you have the arch enemies of each other in the same room on the same panels, and so you're sort of hearing what's going on the other side. That the focus with DHP is not so much the food packaging, because it's been eliminated from so many of these food packaging suppliers. It is the exposure to DHP in the food processing chain. So if you have large vats, you have big, plastic containers that, store food that's being, mixed and being processed, even that temporary exposure may pick up little traces of the DHP, and even though you put it in a DHP pouch or other container for the consumer, there's DHP in the product. So that's of a great concern. And then, of course, lead. Lead is always an issue. Lead is one of those things that, everyone's very afraid of, and there's been a lot of reformulation to eliminate lead from a lot of children's products and other things, but lead is often a naturally occurring process. And so we see it we saw a spate of cases with the food supplements and all of the minerals and so forth and lead. So that's a great concern. This brings me to my last slide, and how am I doing on time?
Good.
Okay. Last slide is sort of, what does the future hold for Prop 65? Well, it's a very interesting thing that's happening in general, but specifically in Prop 65, is the battle of the federal government versus this sort of alternative federal government that's in Sacramento. I sometimes feel like we have like two capitals. We have Sacramento and we have Washington, and they're kind of going in opposite direction on everything from global warming to, a lot of other issues. And you see this in Prop 65. So I talked for a couple moments ago about acrylamide and the about face that OHIA did on acrylamide. Well, the FDA shot a letter just a few weeks ago to OHIA on acrylamide. And they basically said, I'm paraphrasing, but they basically said, hey, we saw what happened with the coffee case, Judge Burrell, and we saw that you did a little bit about face. And they sort of pat him on the back, and they said, that's a good thing, because we recognize that acrylamide, that steps can be taken to reduce acrylamide, but keep in mind that there are bigger issues at stake here. We, as the federal government, as the FDA, are making recommendations as to how much various nutrition qualities people should have in their meals. And of course, whole grains is one of those. And what we don't want to happen is for someone to see a Prop 65 warning on whole grain cereal and say, oh, well, because there's acrylamide in whole grain cereal, I'm going to change my dietary habits. And I'm going to go with my double macchiato and croissant for breakfast every day instead of my whole grain cereal because I want to avoid acrylamide. And so there's a little bit of sharp elbows going on right now between the FDA and OHIA on these issues. And this shot across the bow, as I like to call it, from the FDA was just sort of a reminder that, hey, we're still the FDA here, and we have bigger issues than your junk science out there in California. And we're going to be watching what you're doing. And we have this little thing called preemption that we can sort of indirectly give you the backhand by promulgating regulations that will essentially preempt Prop 65. And so it's going to be interesting to see what happens over the next couple of years between the FDA and OHIA on Prop 65. California continues to be very enamored with what's going on in Europe with the EU regulators with chemical exposure. And you see that they put if you just even go to their website and see their fact sheets, they put a great deal of emphasis on what the European regulators are saying on DEHP and other chemicals. And so they're sort of bypassing, I think, sometimes what the FDA says. In the meantime, a number of other states have decided to start getting into the action, although they don't have things quite like Prop 65. A number of other states have started to legislate in this area and require warnings or prohibit certain chemicals. And therefore, we're starting to end up with not just federal regulations and Prop 65 that have to be of concern, but a whole patchwork of state regulatory schemes that are of concern. They're starting to spout up. And as a result of that, there's a growing movement to get some bills through Congress that will have some uniformity to food labeling, and that would have a preemptive effect over Prop 65. Whether that's successful or not is probably actually going to depend a great deal on whether Republicans retain control of the House or not. But that's what's going on right now. Yes?
General question, Prop 65 and other labeling regulations. Aren't most of these state-level labeling regulations likely to violate the state commerce clause?
You know, it's been tried unsuccessfully. I remember, I think 18 years ago was when I did my first Prop 65 case. I'm sorry, repeat the question. I just got the sign in the back. Do these Prop 65 case laws violate the Interstate Commerce Clause or the Dormant Interstate Commerce Clause by essentially regulating commerce outside of California? And you know, 18 years ago, I remember my first Prop 65 case, and it was a big case as part of an industry group, and so I sort of was the junior guy at the table. And I was enamored with the concept because someone brought up the idea, and I know it's been tried a number of times. It's never been successful. So really, it's been the defenses, the sort of big constitutional defenses or federal government defenses have been preemption, Dormant Commerce Clause, and First Amendment. And of all of those that I would expect to not succeed would be the First Amendment, and it's the one that's most recently succeeded. So.
You have another question over here.
Yes.
I was just curious about that because has it gone outside the Ninth Circuit? I mean, I understand the Ninth Circuit may be agreeing with California, but has anybody ever filed outside? I mean, my company, we do everything we can not to sell to California for lots of reasons. But we sell to companies that our product ends up on their product that goes into California unknowingly.
Yeah, as an ingredient?
Yeah, so who is California to, I'm not selling into your state directly, so I mean, who are you to regulate? It is the state, not you. I'm just wondering, is there anything outside the Ninth Circuit challenging the constitutionality of this? Because I would imagine maybe like the Fifth Circuit or the Fourth Circuit be a lot more open to that argument than the Ninth.
I don't know if it's ever been challenged outside of the Ninth Circuit, but you know, I think it's a valid argument. And the easier way is just through preemption. If you get uniform standards that expressly state that we're preempting Prop 65, you know, that's a shorter intellectual path than
Relying on
commerce.
to do something.
Yeah, you're exactly right. Yes.
And that kind of goes to my question on this. I don't understand the point of FDA's making this claim. In light of the cases where it really takes congressional action, so what that, you know, they think it might conflict with their nutritional advice? That doesn't seem to, I mean, they're not quite saying it's preempted.
Well, I think.
Repeat the question.
So the question is, what is the FDA saying here? Because they're not saying it's preempted. And you're right. They're not saying it's preempted, particularly because it's somewhat moot, because OHIA changed their stance on acrylamide in coffee. But they're talking about acrylamide in general. And they're essentially saying, make sure that when you're implementing your regulations, including acrylamide, you keep in mind the bigger issues that we're concerned about, which is nutritional, you know, getting all the nutrients you want. And I think what they're saying is, had you not changed course on acrylamide in coffee, we would have taken some action.
So almost a, what am I thinking about? The primary jurisdiction type
Yes.
argument where, you know, they're saying, yeah, it's not preempted, but we have a body of knowledge. We've spent a lot of time looking into this. We're very concerned about what this is going to do in terms of consumption of healthier foods, and we're not telling you you can't, but we're advising you shouldn't.
Right, that's right. And so then the final issue that I think we're starting to see, particularly in some federal courts, we're starting to see that courts are questioning some of the science behind Prop 65. The Wheat Growers Association case that adopted the First Amendment defense was based on this being, there being a lot of controversy and the science being completely unsettled. And so I think that's a good thing for industry is we, I think, have a little more traction with saying, just because OEA has said this, it doesn't mean that it's set in stone. Just because some European regulators have said this doesn't mean that it's settled science. So I think courts are a little bit more open to that. But again, who here wants to raise their hand and say, I'll spend my litigation budget next year with a $2,500 per exposure case? You know, a lot of times the way these cases start off is someone says, you know, I'm going to fight this. And about, you know, 3 or 4 months into it, they're saying, let's see if we can settle it. So that's why very few of these cases actually are tried. So, all right, I'll turn it over to Chip for the balance.
So we're going to segue. I mean, the whole idea with Prop 65 is, and the science can be the subject of dispute, but the idea is, at least in theory, these are some things that can hurt you. And so we need to worry about it. So now we're going to talk about things that no one really thinks can hurt you, but that doesn't mean you can't be sued for it. And when we did a presentation on kind of hot topics in litigation last year, we tried to cover the waterfront really and do a lightning round. And we said, well, we're going to narrow it down a little bit. So we're going to talk about a couple of thematic areas rather than try to let you know every important case that's happened in the area. So anybody have an idea what the connection is between these two products? All right. What's that? Nope, not coconut oil. Malic acid. All right. So malic acid, it implies it's an acid. It's used for a couple of purposes. It's an acidulant, so if you want to change the pH of your product to retard bacterial growth, for example, it's useful in that. It's not a flavor, but it affects taste. And taste and flavor are two different things. So, for instance, in something that contains fruit, it doesn't impart its own flavor, but it brings a brightness to the fruit, if you will. These just look like ordinary potato chips, but I assure you these are actually salt and vinegar flavored potato chips. I had to work very hard to get a slide of salt and vinegar potato chips. So salt and vinegar potato chips, to recreate the tang of vinegar, they use malic acid. And there are a couple of different forms of malic acid. Malic acid is naturally occurring in apples, for example, and in other fruits in smaller quantities. And so you can go to a material supplier and get natural malic acid that's derived primarily from apples, but it's much more expensive than the synthetic variety, which is 50% natural and 50% synthetic. So the natural is L-malic acid, and DL-malic acid is the synthetic. I know that's fascinating to everybody. And so why do we talk about these? There are a bundle of cases in which the claim is not that the malic acid is going to hurt you, particularly in the quantities that are used. It's a very small part of the ingredient list. But the claim is that if you hold out your product as being natural, that you are somehow misleading, primarily under the, what do you call that, your trilogy of cases?
The unholy trinity.
The unholy trinity of cases, or statutes rather, in California on consumer deception. The idea is, well, I, the plaintiff, swear on a stack of Bibles that I'm very concerned about the health of my family, and I only buy natural products, and I was absolutely appalled to learn that you may have synthetic malic acid in your product, even though the quantities of malic acid are infinitesimally small, well below any thresholds for anything. And so, and it's not surprisingly the same groups of plaintiffs that do these cases. So for example, in Allred, note the same plaintiff who really liked salt and vinegar potato chips, but different varieties. He had Fritos and Pringles, I think, were the difference here. And, it survived motions to dismiss. And we'll talk about some of the interesting aspects of this, but, the plaintiff comes in and says, you've got malic acid. I think that it is DL, the synthetic kind of malic acid. I would not have purchased it if I had known that. And furthermore, under Ninth Circuit law, which we'll talk about in a moment, I can seek an injunction because now I have no means of knowing in the future whether you're going to have synthetic malic acid, and therefore I have standing to bring an injunction. I mean, just get your head wrapped around that for a moment. So then we have Fitzhenry Russell versus Dr. Pepper. This involved ginger ale, and I think it's Canada Dry ginger ale, and they said made with real ginger, and they have the ads with the guy pulling, you know, cans of ginger ale out of the ground and all this stuff. And the claim is, yes, you go way back and it's real ginger, but then it's processed and all the rest, so they're really getting some kind of ginger concentrate. And again, that survives a motion to dismiss. The General Mills glyphosate litigation here in Minnesota, Judge Davis came out the other way and actually did grant a motion to dismiss on the grounds that no reasonable consumer would reasonably believe that the Nature Valley granola bars, despite being labeled Nature Valley, would be free of even the slightest trace of glyphosate, one of the evil chemicals that Kent was talking about. And we'll talk in a moment how this has reemerged as a trend. But again, the claim was, you know, glyphosate is used as a desiccant to dry crops in addition to being the primary herbicide in Roundup. And you know, through the supply chain, whether it's drift or whether it's used as a desiccant, very, very small amounts in the, you know, single or whatever parts per billion, well below any scientific threshold. And so nobody in these cases, we'll see how that's changed recently, but nobody in these cases claims that they're being physically harmed. They just say, if I had known that, I wouldn't have paid the premium price for this. But Judge Davis here in the District of Minnesota said, you know, that doesn't pass the smell test. Just because it says natural doesn't mean there can't be an infinitesimally small amount of something, particularly because the organic regulations, for example, allow for small amounts of you know, synthetic chemicals. And then Kramenhoek, a case involving cereals that proclaimed the health benefits, and I don't recall whether it was whole grains or what it was, but they said, you know, there are benefits to our cereals. And the plaintiff here said, yeah, except you've got an awful lot of cereal, or excuse me, sugar that you're not disclosing, so you're promoting it as being healthy, but we have the unhealthy sugar, and I would not have purchased it if you would have disclosed how really unhealthy it is. And Co versus General Mills, you know, in that case, I'm trying to remember the label there was, it was protein, or extra protein Cheerios. And so the claim was, you know, the protein count included milk, although it was clearly labeled. And also the claim there was that there was some sweetener as well. And so they'd talk about whole grains and all that. And that ended up in a settlement. And just recently, without admitting any liability, General Mills said, look, we'll just change the label. We'll make the font size a little larger on the sweetener and so forth. But the key to all this is that nobody is actually harmed. The claim is economic harm, not physical harm. Oops. All right, so then what changed? Anybody know what $289 million refers to? Yep, somebody said it. Monsanto, exactly. So Dwayne Johnson, a groundskeeper, claims that because who suffers from, I believe, non-Hodgkin's lymphoma, claimed that it was because of Roundup. The key chemical there is glyphosate, and a jury awarded him $289 million. So, you know, it doesn't take a rocket scientist to figure out where the plaintiffs are going to go with that. So, sure enough, starting in the Southern District of Florida a short while ago, a case is filed which represents a bit of a sea change from the whole non-harm litigation to this notion that trace amounts of glyphosate do, in fact, harm you. And the same science that was used in the Dwayne Johnson case comes to the front in this, and there's a group called the Environmental Working Group that just invented its own standard. And so essentially what they did was they looked back at Prop 65, and they said, well, despite the fact that EPA has certain safe thresholds and all that, Prop 65 says here's a lower threshold, and then if you're feeding it to children, you need a tenfold margin of safety, and they go through this whole alchemy and then just invent a new standard. So here, these are parts per billion. So if you work that out and you think how many zeros in a billion, that's not a lot of glyphosate. And the EPA says as long as you're below that standard, you're good. The test results are in this range in terms of what's in Cheerios, which is similar to other products. Cheerios is not unique in this, but the environmental working, I guess it's not group, but whatever this outfit is, they said our child protective health benchmark is 160 parts per billion. You're higher than that, so we're going to sue you. And so that General Mills would not feel all alone in this. A similar suit was brought last week in the Northern District of California against Bob's Red Mill. The guy with the cap, and he's got the mill in the background, and I think he personally goes out and turns the mill and all that every morning. They sued it because oatmeal has similar levels of glyphosate because oats are dried using desiccants before the rains come. You don't want it just hanging out on the plant all the time. So to get rid of mold and all this, they use some of it. And so poor Bob has trace amounts of glyphosate both in his steel-cut oats and in his rolled oats. So they sued him for that and said, Bob with the hat and all this stuff, he just conveyed the image of health. We paid a premium price, and now we're really concerned about it. But not only did we do that, but we think we're actually harmed because it has any of this in it. We don't know yet where these cases are going. They were recently filed, but I would suggest to you that you take and follow these, and we'll try to send out notices to all of you as things develop to keep you abreast of developments, because we've now moved beyond the no harm case to the physical harm case. Yes, please. Correct. Yeah. So the question was, are these consumer class action versus Prop 65? Absolutely. So as Kent pointed out, there are plenty of Prop 65 actions involving glyphosate and all kinds of rules that in California surrounding this. But this is kind of a whole separate thing apart from that. The General Mills case was brought in Florida, I believe the Southern District of Florida. So the idea here is either a whole group of consumers suffering economic loss or now in this new group of cases, physical harm, supposedly. All right? Anybody know what this is? It's not iced tea. What's that? That's not honey, but it could be. It's hard to tell. You try to get your copyright clearances on pictures of things, and it's really hard. This is kombucha, all right, which I just enjoy saying. As a general matter. So why are we talking about kombucha? Because it represents a whole new class of cases. I only have 10 minutes. I'm just getting rolling, Lori. I guess I better talk fast. So in these kombucha cases, it's a whole new class. It's not a consumer class action, but it's a competitor that's bringing these. So Tortilla Factory, an interesting name for a kombucha manufacturer, but they manufacture an alcoholic kombucha labeled as such. I believe the federal regulations say that if your alcohol by volume is 0.5% or higher, it has to be labeled as an alcoholic beverage. And they do that. And apparently, when you brew kombucha, it naturally creates alcohol in the fermentation process and also sugars. So their claim is against all these other kombucha manufacturers, and I love the names of kombucha manufacturers, is that there's actually more alcohol in the kombucha that you buy than is labeled, and also more sugar. And so consumers purchase kombucha thinking that they're getting a very healthful, probiotic, low-sugar product when they're not, and that Tortilla Factory is at a competitive disadvantage because it shrinks its market by labeling it as alcoholic, and the others don't. So this is a case of a competitor bringing the action. And I'll tell you that when I shared this with my teenage daughters, they were very, very interested in the amount of alcohol in kombucha. All right, so a couple of thematic issues that apply. Everybody here familiar with Bristol-Myers Squibb? Not the company, the case? All right, quick review since people were not nodding energetically. The Supreme Court last year came out in a case involving a mass action as opposed to a class action. That is, all the plaintiffs are named, and so it was a group of named plaintiffs from all over the country that brought suit against Bristol-Myers Squibb, which makes a drug called Plavix. And so this, the court, this went up to the Supreme Court. The Supreme Court says, you know, a court in California, this was a state court, has personal jurisdiction over California residents if they can show, you know, otherwise meet the test for a specific jurisdiction. They consumed it there, whatever, but it said, you know, with regard to all the non-residents, they didn't buy it there, they didn't consume it there, it wasn't prescribed there, they weren't hurt there. You don't have any of the necessary elements to satisfy due process under the 14th Amendment, and so you don't have jurisdiction. So your claim or your case can continue with respect to California residents only, but everybody else is out. All right. So, you know, and I'm not going to read this, and you'll be glad to know that, but it is in your materials. But some of the language really gets into a whole discussion of federalism, and it also ties in with the Supreme Court's long line of cases over the last 5 or so years, really trimming back on personal jurisdiction. You know, general jurisdiction is dead, and they're really cutting back on personal jurisdiction. The specific question, and the court said we are not answering this question, is does this ruling apply equally to class actions? All right, and the courts are very split on this, and it has not been addressed very much, but it is a question that is of great import, I suspect, to everybody in this room. And that is, if it applies to class actions, then, for example, if someone brings a class action in Minnesota, but it has a nationwide class, you say, yeah, but if the people in Minnesota didn't eat the Cheerios here or the oatmeal or whatever, didn't buy it here, weren't injured here, et cetera, too bad, so sad, court doesn't have jurisdiction over it. So these cases, and I have not quoted these cases, but I would recommend that you read these cases. The sections that talk about why Bristol-Myers Squibb should apply are really very interesting. You'll notice that they come from 2 jurisdictions. The Eastern District of New York and primarily the Northern District of Illinois. Most of the Northern District of Illinois had a lot of great cases saying, and I'll explain in a moment why, Bristol-Myers Squibb should apply. Recently, a judge in the Northern District of Illinois went the other way, which may tip the scales on this a little bit. But the essential elements are, number one, Bristol-Myers Squibb talked about federalism. The same federalism concerns would apply equally to a class action versus a mass action. Number 2, Rule 23, which is the class action rule, specifically incorporates the Rules Enabling Act, which would mean, particularly in a diversity case, that all of the due process requirements for personal jurisdiction would still have to be met. So why should that be a difference? And then the other interesting thing, the argument on the con side, which are these cases, boo. On the con side, they say, yeah, but it's different because the rules specifically say that non-named plaintiffs in a class action are not to be, the residency of non-named plaintiffs is not to be considered for diversity jurisdiction. And they kind of end it, but the yes cases say, well, that's all very interesting, but that's subject matter jurisdiction. That's not personal jurisdiction, so knock it off. These cases, and then these cases come out the other way. And I'll tell you, this is something Kent and I, and it looks like I'm not going to have time to tell war stories except maybe over lunch, but a case that we're currently handling in the Southern District of California involving malic acid, interestingly enough, we are very much pushing the idea that Bristol-Myers Squibb should apply. There's another interesting issue primarily in the Ninth Circuit, and that is a lot of these cases, you know, particularly because they can't show anyone's really been harmed all that much, is the real juice for the plaintiff's attorneys is to get an injunction. Well, think about that. If you're bringing the lawsuit because you have just discovered that you paid a premium price for your all-natural thing and discover that there's an infinitesimally small amount of XYZ in there, you know, you're now fully informed. What is there to be enjoined? The whole class is now fully informed. what is there to be enjoined? How can there be standing? And under the test that Lujan and Monsanto put out, there's no real harm. How can you have standing? So as we talked about at this conference last year, the Ninth Circuit completely messed this up in a case called Davidson versus Kimberly-Clark involving disposable wipes. And they had to redo the case en banc because, well, they thought they were going to clean it up. They didn't really succeed. But the first case, they came in and they said, well, yeah, actually, even the consumer who knows that the disposable wipes aren't really flushable still has standing to seek injunctive relief because they don't know when they might become disposable in the future, and therefore they don't know whether they can safely buy the product or not, therefore they have standing. And there was considerable outcry over this. So the Ninth Circuit took it en banc, said, okay, we're going to clear this up, and just made it more confusing. In the second case, the only helpful thing in the second case is that the Ninth Circuit did say, you have to do more than just say, really, honestly, I would buy this in the future. It has to be plausible. All right, so it kind of ties in with the Twombly Iqbal theory of plausibility, but the courts are, of course, all over the map on applying that in terms of what is plausible. The last case I'm going to talk about briefly is a case from California Court of Appeal. Was this the fourth? Yeah.
Division.
The fourth division of California Court of Appeal earlier this month. And in this case, this involved one-a-day multiple vitamins. And the claim was, on the front, says one-a-day multiple vitamins, and on the back, in really small print, it said, you have to take 2 of these a day. All right, and so the claim was, well, wait a minute, if you're holding yourselves out as one-a-day vitamins on the front, you can't tell me in the back, I really have half as many one-a-day vitamins because now I have to take 2 of them. And so the court looked at this and said, yeah, the usual defense that people have trotted out that, as long as you have full disclosure somewhere on the label, you can't be deceived. The court said, yeah, no, sorry, we're not going there, and said, we're going to summarize California law, and these are some of the elements. Number 1, common sense, so there's a bright line rule for you. 2, literal truth and literal falsity, and the court said, in some cases, you can get out of jail free card is that something is literally true, but not always. But if it's literally false, and saying 1 a day when you need 2 a day is pretty literally false, we're not going to do that. A bunch of cases involving what the court called the front-back dichotomy, and that is, does the labeling on the back amplify or corroborate what you say on the front, which will get you out of jail? Well, not really jail, but it'll keep kill the claim. Or if it says something completely different than what you said on the front, court says that's not so good. And then brand names misleading in themselves. And since I told you this is one-a-day vitamins that you have to take twice a day, I don't think I need to expand upon that. There is one interesting aspect about this case to think about a little bit. To get to this result, and the court went on and on, in part, it tested the reasonable consumer standard. And the good folks at Bayer said, no reasonable consumer is going to just assume that 1 a day is more than a brand name. They're going to look at the back and see how much vitamin A and vitamin D and all this stuff is in there. They're going to read the ingredient label. And the court said, no, that's not true. This is a very diverse market. Some people are going to read all of the labels and be very concerned about it, and some people are just going to rely on 1 a day, and it went through all these categories. And so the interesting thing is the court kind of teed it up to make clear that it's going to be really hard to show commonality in a class. Now, as you can tell, this case is only weeks old, so we haven't gone there, but that'll be an interesting trend to watch. So how am I doing on time? Right on the dot? Amazing. All right, so thank you all for putting up with my jabbering on this, but we're happy to field questions. Yes? Yeah.
You want to do this announcement?
Oh, yeah. I have to give the official announcement to get paid. First of all, please sign your sign-in sheets because that's your key to getting CLE credit, and also telling people back at your office where you were today. And the second thing is I'm to read the following, and I'm going to read it verbatim. That concludes our first breakout session. We have another set of breakout sessions coming up. If you wish to attend blockchain for the food industry, the essential primer, you will need to go back to the Minnesota room, which is the large room where we started. If you wish to attend the organics, GMOs, and GE markets and regulation session, you can remain right here. And I can tell you, we have fantastic panelists for both of these sessions. I was trying to figure out how to clone myself so I could attend both. Haven't gotten there yet. But we have some technology specialists on both panels that might be able to help us out. Anyway, thank you all.